Thank you very much to everyone for joining us on this first roundtable of the Viscount Bennett International Economic Law Conversations. We do want to thank our collaborators, the MacEachen Institute and the Jean Monnet Institute for collaborating with the Schulich School of Law Viscount Bennett Chair in organizing today's event. We also want to welcome everyone who's taking their time to participate in today's event. We have a host of excellent panelists seasoned in the topic that we're discussing today, one that is extremely relevant, not just for the geopolitical zone of North America as represented by Mexico, US, and Canada, but one that is significant in the context of the ongoing multilateral challenges and how perhaps regional developments at the various levels across the world might inform important thinking for the future of multilateral trading regime and Geneva in particular. So I do want to welcome everyone and look forward to important conversations today. Just the first thing to also note is that this event is being recorded, and so thank you very much for observing the rules relating to keeping things as quiet as possible. We will shortly move on to the real conversations from our panelists. I'm looking at the messages on the side. We were to have Dean here. I imagine she's caught up in a meeting, but as soon as she comes on, we'll have her say a warm welcome to you all who have joined us virtually at Schulich School of Law. Without much ado, I'd like to turn on the conversation to our panelists. This is my duty today is to moderate, and I'll do that giving the floor as much as possible to our panelists for their conversation. But before doing that, our Dean is here indeed. So permit me to now bring on Dean Camille Cameron. She has just joined us, and so Camille, you can have the floor now. We have just started.
Thanks very much, BC. I was a little bit late checking in, but the technology worked for me in the end. So welcome, everyone. It's a pleasure to have been asked to give you a very brief and I hope a very warm virtual welcome for this event. I'm pleased to be able to do it. I want to start by thanking Professor Olabisi Akinkubi, our Viscount Bennett Chair, for taking this event on and for doing the work which everyone knows is required to make an event like this happen. It's a great event, but it takes a lot of work. So I'm really thankful that we're doing this. I'm also pleased that we're collaborating again, as we've done in the past, with our Jean Monnet Center here and with the MacEachen Institute. It's great to be able to have those collaborations. We've got a very mixed group of participants for this event, from the academy, from the private sector, from government, and from law firms. So it's great to be able to have that mixed group. And it's not surprising, of course, given the import of the topic that has been chosen. I want to give a special thank you to the panelists as well. Of course, these things take time. You're all busy. So we're really appreciative that you've been willing to jump in and to join the event. So that's basically it. Just the warmest possible welcome one can give virtually. And yeah, thanks a lot to everyone for participating. And I'll turn it back over to BC. Thank you very much, BC.
Thanks a lot, Camille. Extremely kind of you and supportive of the Schulich School of Law as well. So now we'll go to our first panelist, Camille Martini. You are on now. In my moderation sessions, my cue to your time almost over is once I come on with my mute turned on. So that's it. But Camille, over to you now, Camille Martini.
Thank you very much. Busy, do you hear me well? I assume you do. Okay, let me know if you do not. Thank you very much for the kind introduction, Busy, and for hosting this event. I'd like to thank the School of Law as well for the kind invitation. It's a real honor to be part of such a distinguished panel. My first round of remarks will be dedicated to sharing some practical views, as well as discussing recent development in Europe, which hopefully will set the stage to a further discussion with the panelists. As an introduction, and please allow me to share my screen. Here you go. I thought that it would be a good idea to walk you through recent events related to ISDS, both in North America and Europe. And you can see that on the timeline. So it's very my choice of events to illustrate the topic today. The main takeaways of this timeline, in my view, is that ISDS and investment protection have been under close scrutiny, both at the judicial and political level. And you can see that on the screen. I'll start with recent events in Europe, but I promise I will turn to the subject matter of the day, the USMCA or CUSMA, depending on the country you want to put first. First, you will note that on August 29, 2020, 23 EU member states signed an international agreement which automatically terminated 130 intra-EU BATs, while also abrogating the treaty's so-called sunset clauses. And by intra-EU BAT, I mean signed between EU member states. 3 judgments of the Court of Justice of the EU are also worth mentioning here because they illustrate the active role played by EU institutions to limit the recourse to arbitration as a means to resolve investment disputes within the European Union. The first one is ACMEA. Of course, I assume you've heard about it, but basically very short. The court ruled that ISDS under intra-EU BATs impaired the autonomy of EU law and was therefore contrary to it. The second one, the Chromosoid Judgment, dated September 2nd, 2021, so very recent, in which the court found that the investor state arbitration clause in the Energy Charter Treaty, ECT, was, for the same reason, inapplicable to disputes between an EU member state and an investor of another member state. And the third judgment was issued only a few days ago. The Court of Justice in this one prohibited the conclusion of, by a EU member state of an arbitration agreement with identical content to an invalid arbitration clause in a BIT signed between EU member states. Invalid, of course, in the view of the Court of Justice. This does not mean that investor state arbitration within the EU is to be banned forever, of course, but as a result of this decision, an investor cannot successfully argue to circumvent the ACMEA decision that he could file a request of arbitration that would be an offer to arbitrate that the state can accept tacitly by continuing the arbitration without objecting to it. So less arbitration possibly in intra-EU investment disputes. What about in relation to third countries? So EU with third countries, and I promise I'm going to turn to the USMCA very shortly. As you know, the European Commission has negotiated new generation agreements with third countries and these treaties. You have 2 examples mentioned on the screen, tend to contain reference to the newly minted multilateral investment court system, the one the EU is promoting within the UNCITRAL Working Group 3. And actually the next session is happening in a few days as a replacement of the older generation and traditional ISDS in BITs. I'd like to turn to some numbers that will hopefully illustrate what we mean by dispute settlement under the USMCA. I mean, so far, so since July 1st, 2020, which corresponds to the entry into force of the USMCA. Of course, no case under EU trade and investment agreements because most of them have not yet entered into force, at least not their investment chapters. And on the North American side, I was able to identify 10 disputes since July 1st, 2020. And we're talking about, for 3 of them, actual arbitration ongoing because a request for arbitration has been filed, or notices of intent that would indicate that an arbitration might be launched in the near future. As you know, NAFTA remained in force until July 1st, but foreign investors with a so-called legacy investment may bring claims against Canada, the US, or Mexico under the provisions of Chapter 11 of NAFTA for 3 years after the termination of the agreement. So that means until June 30, 2023. And all of the 10 cases listed on screen rely to some extent on this legacy investment mechanism, which is set out in Annex 14C of the USMCA. What conclusion can we draw from those numbers? We haven't seen an increase in claims brought by investors seeking to rely on that legacy investment claim mechanism so far. This may change as we get closer to June 2023, but I think it's interesting to have a look to what the claimants have brought before those 3 arbitration panels, or what they listed as potential violations in the notice of intents, by having a look at the nature of the claims raised by these legacy investors, at least in the 7 cases in which I was able to retrieve information about the alleged breaches in these cases. It's interesting because, as you know, the state parties to USMCA decided to limit the types of claims that may be raised under the agreement. And by state parties, I meant to say annex parties, which are the US and Mexico, because we'll talk about that later. As you know, of course, Canada opted out of the ISDS mechanism in the new treaty. And as you also may or may not know, some types of claims have been, the nature of the claims you can brought before a USMCA tribunal have been limited to some extent. Direct expropriation and discriminatory treatment, but not violation of the minimum standard of treatment or free transfer or other types of breach, so narrowed down to several types of violations, and all of the violations you see on screen may not be covered by the new agreement. And as additional information, in certain covered sectors, oil and gas, power generation, for instance, the USMCA grants wider ISDS protection to investment with a covered government contract. That's Annex 14E, I believe. So that's distinct from what I just said. Let me turn to the next one. I see that time flies. I'm going to talk about the breakdown of legacy claims by nationality of the parties. And I think that's going to be interesting for the discussion that's going to come after me. You see there's a sharp difference in the nationality of the claimant and the respondent in those 10 cases. The color code is telling on the screen. Here again, because of Canada's opt-out from the ISDS mechanism applicable to the investment chapter of the USMCA, a tribunal would lack jurisdiction over cases involving Canadian investors or Canada itself as respondent if filed after July 1st, 2023. But please recall that other routes may be available to Canadian investors in Mexico and vice versa, such as the TPP. So as food for thought, note that no claimant have been successful so far, to the extent of my knowledge, in pursuing a Chapter 11 claim against the US. And among them, I counted 17 Canadian investors. So Canada may have made a good deal in opting out from the ISDS mechanism of the USMCA in that respect, but I leave that open for discussion. What I suggest now is to have a very quick look at some of the key provisions of the USMCA. So I believe on screen we have covered some of the changes to the ISDS mechanism in the USMCA compared to the old NAFTA. As for the EU, as you may know, many new treaties not yet in force contain a reference to an ad hoc tribunal with an appeal mechanism and an agreement to agree at a later stage to an investment court system that would involve more countries than just the parties to the EU agreement. With respect to the minimum standard, and I have less than a minute to wrap up my intervention. So I would say that both the USMCA and EU agreements, again, with the idea that each agreement is different, of course, they tried in different ways to narrow the scope of what FET means. So in the context of NAFTA, it's been clearer since the clarification from the parties, but for the EU, a list of sub-elements that would constitute a breach of the FET, and you'll see that there's an interesting paragraph regarding legitimate expectations, and I leave it to you whether you feel the two standards are maybe closer than they seem, although the EU agreements don't refer usually to the minimum standard in the customary international law. Last slide for me, and I'll stop here, is the expropriation standard. And I think it's interesting because both agreements tend to contain an annex that limits the scope of what we mean by indirect expropriation. I think the USMCA went further than EU agreements in that respect, and we've seen similar annexes in Canadian treaties, FTAs, and some cases that were recently published show that this type of annex can be extremely efficient to narrow the scope of what could be a violation of the expropriation standard. As promised, I leave the floor now to my co-panelists, and I'm of course happy to entertain questions later on after the discussion. Thank you very much.
Thanks a lot, Camille. You've done it the way we hope to continue, right? Keeping this to time, but also very interesting to set the stage for the conversations, not only by focusing on those, if you like, overlaps, maybe differences, maybe, conflicting circumstances between those specific provisions in EU agreements and the CUSMA, as well as the general introduction. So thank you very much. And I think the next panelist presentation really moves us along very well in that regard. So I'll call on Professor Sergio Puya, as a professor at the University of Arizona. Sergio, over to you. Thanks.
Thank you so much. And I just want to do a couple of remarks to center our conversation, because I think that's the whole hope of this panel. And as you know, the USMCA was signed under a kind of a renewed mistrust of international trade and international organizations in general, and kind of in my way of view, it may reveal what trade and investment deals, at least signed by the US, will look like in the future. In some way, it may retrench and build on the events at the WTO, and creates what I describe as the revival of zones of interest, right? That were very, very problematic during the Cold War. The USMCA also anchors North America as a production zone, right? Consistent with what was the NAFTA, but it's more obvious that now it's a production zone in contrast to China. Let me just touch on 3 points that I think are interesting and perhaps underappreciated, that in many ways could actually help in our biggest battle for the future, which maybe is climate change. And we can center, if possible, our discussion on that. The first is the ISDS, as Camille was saying, is now not longer active between the US and Canada, and maybe that's a good thing. But it is also more restricting between Mexico and the US. There's less rights for investment, so the rebalancing is going in one direction, right? In states reclaiming interpretative authority of the treaty, and it introduces what I think are better practice, at least in appointments of arbitrators, and of course the ethical aspects of ISDS that have been highly criticized. Perhaps underappreciated is also the role of the Commission, right? That the Camille was referring to the Commission by means of the interpretation of the Article 1105, that famous note of 2001. Well, now the Commission has more authority, including the interpretation of any aspects related to non-conforming measures, and that's going to be interesting as well. Now, on the general state-to-state dispute settlement, right, just moving a little bit out of the, the more shiny aspect, which is always ISDS, but the state-to-state actually has some interesting aspects. It also now is a complete system that prevents frustration, and some of you may remember that that was the main issue with the state-to-state dispute settlement of the NAFTA. After the famous case involving the trucking sector, where Mexican trucking interests were espoused against the U.S., that system collapsed, and then there was no way to really complete a panel without the agreement of the states. Now, in this case, it is possible, right? If a party fails to establish a panel, then there's a mechanism for that, and it can be it will come out from a roster of arbitrators that have been already appointed. Here, I also think that what's a little bit underappreciated is the demand for expertise, and it's interesting, right, that now it specifically requires experts in international trade or other matters, and in disputes involving environment of like Chapter 24 now demands that the chair, the panelists other than the chair, have expertise in environmental law, which I think it's a very welcome. In the state-to-state dispute settlement process, there's another aspect where I think people haven't zoomed in, but I think it's rather interesting, is this idea of remand. And Camille was mentioning the European Union, the remand, sending a question for interpretation of a different body is a common aspect. And here the Commission has the possibility of interpreting on remand issues brought on by domestic judicial or administrative proceedings of the parties to the NAFTA. And that hopefully will work well, because that will lead to better interpretations by domestic courts, and perhaps that take away some of the issues from international dispute settlement. And finally, the most, I think, in my view, interesting aspect of the agreement, although it's controversial and we'll see how it works, is the rapid response mechanism for arbitrating rights. It's, we can dive in the discussion, but basically it is a mechanism that permits the exclusion of goods from specific locations that are deemed to be in non-compliance with the labor standards established by the agreement. And just as a matter of reference, Mexico has a large commitment of overhauling its domestic labor laws and institutions as consequence of the agreement on other reforms made in Mexican law. So this is a very interesting, process that is expected to be resolved in 120 days and can suspend tariff treatment or other benefits of the agreement in less than 120 days. Now, coming back to my first point, right? I think thinking ahead, the future treaties can think of the NAFTA as inspiration for three issues, right? One is the need to exclude some sectors for ISDS, or some people have actually argued that, and maybe we can hear that from my co-panelists, that maybe the ISDS should not be a part of future agreements, right? That's possibly a good thing if we want to transform our energy future. So in part, in most cases of ISDS, and I was just looking at the cases referred by Camille, involve the oil and gas and energy production. And if we want to have clean energy, perhaps that's a way to go, excluding excluding some sectors or ISDS altogether, for at least for sectors of high intensive and CO2 producing industries. I think for the purpose of the state to state, I do think that the requirement of environmental expertise for disputes involving the environmental chapter and litigating those, it's an interesting idea, as well as the remand to the commission. And I think the labor rights mechanism, especially the rapid response, could serve for inspiration to include a similar type of mechanism to enforce commitments to reduce CO2 emissions. Perhaps it can be modeled in some way, right? Perhaps not hasn't to be the rapid response that is necessary maybe for a labor mechanism, but it can be inspired in this in the way in which specific facilities can be targeted for non-compliance with commitments. For now, I would just leave it there, and I hope we can have a conversation. Thank you, and thank you everybody for being here.
Thanks a lot, Sergio. A lot of food for thought you put on the table there. On the question of USMCA innovations to enhance social policy, as you've said, and the potential really of ISDS dispute regime to enhance labor and environmental issues. And I mean, I think many will probably want to have that conversation around, whether ISDS or investment trade investment agreements generally, right, is the place for us to be having these difficult conversations around, climate change and climate justice and so on and so forth. So thank you so much for that. Okay, so I'll move along quickly to Professor Andrea Bojland. She's a colleague on the Canadian side of the dispute. So I feel like now I have my own person, so to say, quote and unquote speaking. Not to say that all the panelists are not my person, but again, I'll now move on to Professor Bojland. Thank you.
Oh, BC, thank you very much. And thank you for the invitation to be here. I'm not sure that I should confess to you that I'm an American citizen, or you'll feel you've got me here under false pretenses. So I do think I have somehow a foot in two of the three NAFTA camps. It's a pleasure to be invited to reflect on the USMCA a little bit more than a year after it entered into force, and to try to, it's always tempting to try to read the tea leaves for what things are going to happen in the future. One thing, coming third, I have the advantage of following two excellent presentations, and I am, so I was inspired a little bit by Camille's presentation to think about from the North American point of view. Really, I probably would have started that timeline much earlier, because I would have started in the year 2000 with the concerns about NAFTA raised at the time in the U.S. Congress, and to a little bit lesser extent, but still quite vigorously in Canada, because you saw some of the same concerns about ISDS raised then. There were, Senator Kerry, who was then a presidential candidate, said, that if Congress had known what was in NAFTA, that there was this Chapter 11, they never would have signed it, and how dreadful this all was. And the Trade Promotion Authority was amended to require that there would be no greater rights given in investment agreements than were available to U.S. investors. Or to U.S. investors in U.S. courts, and you had the requirement that the U.S. government consider establishing an appellate body. And so you started seeing plugins for appellate bodies in the U.S. Investment agreements, even though nothing ever went forward on that front. And in a kind of deeply ironic sense, I think that's because the OECD countries, the European countries, had no interest in an appellate body in the in the 2000s, before 2013, just absolutely no interest at all. So it's interesting now to see your timeline, starting in after the EU really takes confidence over investment in Lisbon and really engage, and the Commission really engages in it, to see that, now you have this other timeline that it seems like we're leapfrogging, like what the US wants to do, what Europe wants to do, what the US wants to do, what Europe wants to do. Does the US, so that's one kind of interesting feature. Another thing that your timeline and your excerpts of the provisions kind of reminded me of, and again, I'm going to take the North American perspective here, which is that really the United States and Canada have succeeded in exporting a lot of their investment agreements. A lot of what was originally in NAFTA, and then which was, expanded upon and elaborated in the various iterations of the model BITs and further investment agreements or free investment chapters of free trade agreements of those two countries. So when you look at the CETA, for example, I think you can see a direct lineage. You really see the influence of the Canadian model FIPA in the CETA. And that has really colored the European approach, going forward. I'm not suggesting that Europe hasn't made its own contributions, and I think the fair and equitable treatment provision is a real example of that, where you can see that it's not the Canadian and American approach to saying minimum standard of treatment, customary international law, but really an attempt to spell out what that is and to make sure that tribunals can't go forward. But nonetheless, I think a lot of influence on that front. And so because of that, it's interesting to see how the US has really seemingly retrenched from its positions, even the positions it seemed to have early in the Trump administration. So I would have said, and others who might have been there might have had a different impression, but in the working group 3 interventions of the United States, I would say the early approach was, you should just we don't need an investment court, but you should do what we've done, which is to really refine our treaties and to have, investor state dispute settlement with all the bells and whistles. And this is what, this is the way forward, and this is the best way forward. And that has gradually changed into a much more skepticism on the part of the US to investor state dispute settlement, as we see reflected, I think, in the USMCA, where you have the abandonment of it with respect to Canada, retention of it with respect to Mexico, but in a relatively an asymmetric way. Camille alluded to this, but you really have the exclusions of claims for violations of fair and equitable treatment, except in matters relating to very specific government contracts in covered sectors. And in this particular case, those sectors, I'm going to oil and gas, power generations, telecommunications, transportation, and infrastructure. On the whole, those are all going to be US investors in Mexico, not the other way around, because those types of contracts either don't exist or they're excluded. They're part of exclusions in the USMCA, so that you're really seeing kind of a return to, if you will, to a really capital exporting, capital importing kind of dynamic, which is, well, at the very least, it is interesting. And maybe it was, it got through Congress with bipartisan support. Might have made it been easier to get that through Congress, which I think has a general anti-ISDS bent, given that there was no ISDS with Canada. So that was also a limiting feature. This maybe suggests that existing provisions are not going away, especially if the US has offensive interests. I don't think there's a global desire to rescind all of the US investment treaties, existing treaties, but it's hard to believe there's going to be much on the agenda of the Biden administration moving forward, partly because the political alignments in the US are such that there is no longer the broad center coalition, I think, of Democrats and Republicans that are really engaged in a pro-free trade, pro-investment, pro-exporting of investment agenda. And also because more pragmatically, as we know from the headlines, the Biden administration has many other things to deal with than investment agreements and ISDS. So I'll stop there, and sorry if I've gone on too long, but thank you.
Oh, thanks a lot, Andrea. No, you haven't gone on too long, and I think your own intervention has also very well followed on. We can't discuss these issues without the politics that really animate, moderate, or in the shadow of which they all exist. I really like that, to use Anu Barford's phrase, you brought in maybe the US effect now, right? Not the Brussels one right now, but we can't also deny the fact that these things have impacted and shaped a lot of trade and investment agreements elsewhere. So thank you very much for those initial reflections. So on next is Professor Frank Garcia, and just a minute of word before going on to that. I have to say this. Here I came across in an email first when I wanted to publish a book review in 2012, and we didn't get to speak until recently when we met on the board of the same journal. And he was kind enough to reach out afterwards to say, look, what are you doing? What's on the horizon? I was like, I'm thinking about this. And so he's like, I'm thinking about these issues too. So I thought, oh, let's put forces together, with Boston College of Law, have you here. And so, Frank, thank you so much for the support. It's great to have you here as part of this panel.
Well, thank you very much, BC. It's very good to be here. And as any of you who know BC can also attest to, you don't have to spend much time in his company to feel a desire to do something together and tap into that enthusiasm. So I'm sure I'm not alone in that. So thank you. I want to offer a certain perspective on some of the issues that some of my colleagues have already touched on. And that's to look at the question of dispute resolution from the point of view of procedural justice. Now, procedural justice, you can think of the procedural justice literature from a normative perspective or from an empirical perspective. And I'm going to be looking more at the empirical perspective, which draws on the work of Tom Tyler and social psychology and some of his colleagues. And the basic question there is, what are the key attributes of any dispute settlement process that will render it legitimate in the eyes of its participants? In particular, that will lead them to find negative outcomes acceptable because they have a basic faith and trust in the process. So for obvious reasons, that's quite important in the current debates about ISDS, where a number of participants and stakeholders, for a number of reasons, find the system lacking with respect to legitimacy. And it's not too hard to see why when we take a look at some of these procedural justice norms, which I'm going to look at in a moment. But I wanted to just clarify a little bit at the beginning that from my perspective, what the CUSMA treaty does is it creates really a framework that includes 4 different dispute settlement mechanisms or approaches, if you will, within the NAFTA space with respect to investment that used to really just include 1. So I'm going to be focusing my remarks on the specific mechanism of ISDS in the treaty, but I'll touch a little bit on the others because really it's important to see in a collective sense what is the quality of procedural justice available in North America with respect to investment, and that's really a fourfold process or a fourfold framework. So procedural justice has a lot of different elements to it depending on the type of government procedure that we're looking at. But I think with respect to investment arbitration, there are 4 that are particularly important to pay attention to. The first one is the independence and impartiality of the decision makers. And I don't need for this audience to recite some of the standard concerns and criticisms that ISDS has received with respect to the independence and impartiality of its arbitrators, or at a minimum, the perception of independence or impartiality or not of its arbitrators. Second is transparency. And transparency is important in itself and also instrumentally. It's important in itself with respect to parties being able to see and access the basis on which decisions are made that affect their rights and their interests. But it's also important instrumentally in the sense that if you want to assess the independence and impartiality of the decision maker, there has to be a certain amount of transparency. If you want to know whether your rights and interests are in fact affected by a decision or a proceeding and its outcome, there has to be a certain amount of transparency. So that interest touches a lot of aspects of the process. The third one is participation. And Tyler and his colleagues emphasize that this is a core value for any proceeding, that those whose interests are affected by it have some meaningful way of participating in the proceeding itself. And the last one is some mechanism for the correction of error. And again, with respect to the current debates around investment arbitration, I don't need to mention again for this audience the number of complaints and concerns around the quality and variability of the different awards that are circulating in the investment arbitration world. All right, so let me look first then in terms of these criteria at the procedure that's set up between the United States and Mexico. And I would say sort of overall that we could characterize this as a modest improvement with respect to procedural justice criteria. Perhaps one of the most noteworthy places you can see it is with respect to the independence of arbitrators. The new treaty incorporates the new IBA rules on conflict of interest. And I don't offer an opinion on whether those are adequate or inadequate, but at least they're incorporated. And in an interesting innovation, the treaty imposes some limits on this practice of double hatting, which I might just explain briefly for some of you who may not be familiar with the term. It's when someone who is chosen to sit as an arbitrator in one proceeding is simultaneously participating as counsel or expert witness in another proceeding. So it's a practice that concerns many people, at least with the appearance of impartiality, if not the actual substantive conflicts that might bring. So, however, and you'll see when I compare this to the TPP, the US-Mexico standard against double hatting is rather disappointingly narrow. I'll quote from 14D that any arbitrator shall not for the duration of the proceeding act as counsel or a party appointed expert or witness in any pending arbitration under the annexes to this chapter. So it's that last bit that turns out to be quite narrow, but I'll say more about that when I go to the TPP. All right, so independence, some improvements. Transparency, also some improvements. Whereas under the NAFTA, there was only a requirement that the award and the notice and the request for arbitration be publicly available. That has now been broadened to include the pleadings, the memorials, and in fact, a requirement that the proceedings themselves be public, unless the parties have reason to limit them in certain cases. So that is a significant improvement with respect to transparency. However, I think a significant missed opportunity here is there's no disclosure requirement of any kind with respect to the presence or participation of third-party funding. Now that's a whole nother debate about what many, including myself, view as a quite corrosive and serious encroachment into the investment arbitration world. But there's a missed opportunity here. The current best practices at a minimum would require the disclosure of the presence of third-party funding, if not the identity of the third-party funders. And the treaty doesn't even do that much. With respect to participation rights, the third criteria, there's no meaningful improvement with respect to participation. There is a standard mechanism for filing amicus briefs with the permission of the tribunal, but no innovation with respect to participation. Finally, with respect to correction of error, there is a little bit of structural improvement and some interesting possibilities here. Sergio mentioned that there's an expanded role for the commission. So one could see the role of the commission as one mechanism for correcting error, at least from the perspective of the parties involved in the state parties involved and what their official view of how the treaty should be interpreted. So that's not nothing, but it's also, in a way, itself somewhat limited. The general U.S.-Mexico arbitration provision, 14D, Annex 14D, does, as has been mentioned, eliminate fair and equitable treatment as a source of claims. And to the extent that that is one of the places where the current crazy quilt of approaches and opinions is most criticized, then you could see the elimination of fair and equitable treatment as a kind of correction of error, insofar as many errors are on the part of many commentators come in through how that provision is interpreted. There is also an interesting change in that now the tribunal can circulate drafts of the award to the parties before it's published. So that itself could be another place where you might see errors addressed, at least from the perspective of a participating party. And finally, there is an interesting small provision. I haven't spent enough time with it to know if it's meaningful with respect to the correction of error, but there is more flexibility about the seat of arbitration. Now, the tribunal, if the parties don't agree on the seat of arbitration, the tribunal can seat the arbitration in any New York Convention jurisdiction. So insofar as that provides any room for choosing a seat of arbitration where the local courts have perhaps a more progressive or more activist view of their supervisory role, maybe there's a little bit of room there for some correction of error, but I don't know. I haven't spent enough time thinking about that piece. All right, just briefly, since I see my time's moving on, with respect to the second procedure within the NAFTA space, with respect to US-Mexico on covered agreements in covered sectors, it retains the different elements that I've mentioned, so there's no real step forward or step backwards with respect to these innovations, except that the room for claims is broadened out again to include fair and equitable treatment and indirect expropriation. So insofar as that allows for the possibility of more of the kinds of judgments that concern people from a variability and correctness point of view, then that could be seen as a slight retrenchment away from that with respect to correction of error. Briefly, with respect to what's going on then in the third agreement, which is between Canada and Mexico, which now will be the TPP. You know, the TPP and the CUSMA have certain attributes in common, so it's a bit you know, it's in some ways a toss-up which of them is more progressive or less progressive across the board with respect to these procedural justice criteria. I will point out that with respect to double hatting, the rule in the TPP is broader and therefore I think more effective, because it also prohibits double hatting. I'm reading here from our chapter 9 of the TPP. It prohibits double hatting in any dispute pending under the TPP or any other international agreement. So it means now if you're an arbitrator in a TPP dispute, you won't be able to work as counsel or expert witness in any other arbitration pending under any international agreement. So I think that's if we're going to be regulating double hatting, I think that's a more activist, more progressive view of that. Finally, I would say in conclusion, if we're looking at this sort of framework, then the fourth element I haven't really mentioned is the one that's already been touched on, which is between the US and Canada. There is no ISDS has been said, and now it's really up to the domestic dispute settlement mechanisms of each of these countries, which I would just say across the board are going to be much, much more robust with respect to these procedural justice criteria. So I find myself actually in the process of preparing these remarks, sort of reasoning myself to a conclusion that I had not anticipated, which is if you want to take procedural justice seriously with respect to investment arbitration, you actually have to eliminate ISDS. And the fastest road to creating a procedurally just mechanism for resolving investment disputes is to go back to domestic court systems. And I had not expected to come out there, and I'm still absorbing the implications of that for my overall views about the nature and the future of ISDS. If you're not going to do that, then this harkens back to what Camille was bringing up at the beginning. Then perhaps you need to look at something like the multilateral investment court that the EU is proposing, which is far more robust on these procedural justice criteria than any of the ISDS mechanisms we're looking at, but is not as strong as a national court system. So I'll stop right there. All right, thank you.
Thank you so much, Frank. Very interesting remarks there on procedural justice issues. And particularly, right, where you sort of landed there, that there may be a case here to go back to the domestic courts, right? Because if you think about the procedural justice questions in the context of broader third world claims against ISDS, I mean, it's one of the things they're saying. And one scholar whose book is forthcoming, Dominic de Banja, really makes that case so well. He's in Australia. I'm happy to share the link with our audience. So the panelists have been excellent. So thank you very much on these initial remarks, right? And I know there may be interest in responding to each other. So what I want to propose is this for my panelists. I think we have a question that gets us off in the chat, right? It's by my colleague, Meinhard Dohr. So if Meinhard is still around, Meinhard, I want you to come in briefly and state this, and then we can take it as part of the responses that the panelists will have arising from their own presentations as well. Is Meinhard still here? He may have stepped out. Okay, I know he had questions. He had a thing to get to. So I'll read the question, right? And then we'll get on with that. Okay, so he's wondered, that a basic tension in investor protection agreements generally, and dispute settlement mechanisms more specifically, has been the tension between protecting investors' rights on the one hand and importance of protecting competition from eroding social and environmental standards rather than trade as a means of encouraging a race to the top on social and environmental issues. He knows some have touched on this from the panelists, but he wonders if there could be comments on where the USMCA stands on this tension between NAFTA compared to trade regimes. I'm tossing that question in as part of remarks and to go whichever way the panelists feel as a result of this initial first round. Camille, to come back to you, do you want to start first? Because you started us off on all this.
Thank you very much. I may, and of course, it's going to be first round of remarks on the question, and other are free to react. So there is a clause in the new NAFTA, the USMCA, about, what Meinhard referred to. I think it's called investment in environment, health, safety, and other regulatory objectives. That's Article 14.16. And we have had some exposures to the way similar clauses have been interpreted by tribunals. There's been a Bear Creek mining case against Peru, copper mesa mining case against Ecuador. Both of them Canadian treaties, so I might leave Professor Bjorklund a comment as well. And thank you, by the way, for putting my timeline into broader perspective. I greatly appreciate it. I didn't mean to put the EU as the first instigator of the new trend of reforming ISDS. Thank you very much. And more recently, we had the Infinito Gold case and the Eco Oro case against Colombia, and this one is very recent. And I think, so of course, each case is different based on different treaties, and you may not interpret those as how a clause in a different treaty should be interpreted. But it seems to me that those right to regulate clauses have been difficult to implement by tribunal. But what we've seen in the Eco case is that the clarification in the annex of what constitutes indirect expropriation have been much more powerful to exclude from the scope of ISDS some potential breaches or excuse certain behaviors that would otherwise be a violation of the treaty. And I think what I can read in the USMCA clause that a measure adopted for the for public interest, such as the environment, must be otherwise consistent with the agreement. So I think this is something that tribunals have usually interpreted in the past as meaning that the measure at issue cannot be a violation of other clauses in the treaty. I leave it from here, and please feel free to complement what I said.
Thanks, Camille, for those reflections. Sergio, do you want to come in on this? Or indeed,
well, I don't have a strong position on that. I don't understand really how the extent of the relationship between the chapter 24, right, which is the environmental chapter, and chapter 14 of the USMCA. There is going to be an interesting tension if Mexico carries on with the reform of the energy sector, because interestingly, the Mexican reform is now a reform to retake the monopolistic aspect of the former national utility company on the sector, and it does that by forcing the consumption of and production of more or less clean energy, right? So all those investments in clean energy will have or will try to activate the Chapter 14 of the USMCA, and the question will be, what is the relationship with the environmental standards of Article 24? It's a complicated topic. I agree with Camille that basically these provisions and exceptions on the right to regulate are fully satisfactory. I really, a restatement of the sovereign prerogative to regulate. So, I hope, that, that tension gets well addressed. Now, I wanted to also zoom in on Frank's comment on the lack of procedural due process or due process on the NAFTA or the USMCA and its limited correction. And I wonder if, just for the sake of the commentary, if is he aware with the new decision against the Mexican government in Leon versus Mexico, which is a very interesting one. It's the first denial of justice decision that basically, puts the point on a very problematic aspect of Mexican judicial institutions, that if they have been improved in the last few years, not sufficiently, and then they still opt for this type of behavior. And, in short, is a rather terrifying action, really, by the courts or by the Mexican courts that allow this really terrible fraud against investments. So I, with the exclusion of now minimum standard of justice, and do you see how these decisions should be addressed in domestic courts, or you think like then questions like this should be addressed on a state-to-state dispute settlement process? How we reconcile these two aspects, right? That there's still deficiencies of procedural justice, which, by the way, I'm sure, right, if we go back to Lowen, this whole case of NAFTA, we could point to the same aspects of deficiencies in procedural justice in domestic court. So I still think there may be a room in the future for international dispute settlement, but I want to agree with your impulse of saying, well, but maybe ISDS is not the right one. So what is your take, and Andreas as well? So.
Thank you very much, Sergio, for teasing it up again in a very interesting way. Over to you, Andrea.
Well, so to take the latter point, I was thinking of that too, Sergio. I'm less convinced, I think, than Frank is that in particular, that domestic courts are the best alternative. Sometimes that might be true, sometimes that might not be true. It depends on the court, it depends on the independence of the judiciary. It depends on, I mean, as far as transparency is concerned, actually jurisdictions vary enormously with respect to transparency. So even countries such as Austria, first instance decisions are not published. They're not made public. They're not only appellate court decisions are regarded as necessary to be published. It's a civil law country. The first instance decision has no precedential value, and therefore it's viewed as not interesting or necessary to anybody but the disputing parties. And in many civil law countries, you don't have participation by civil society. You don't have amicus curiae participation. So I'm not so sure that domestic courts satisfy those criteria either. So, does the new NAFTA go far enough on those fronts? So that depends on your point of view. I mean, that's, but I sometimes wonder, and I mean, whether, especially with things, I'm going to say like participation and like amicus participation, in domestic courts, even in the United States, where we have a robust practice at the Supreme Court and in appellate courts, it's not a matter of course that an amicus gets to participate. It is a matter of discretion for the tribunal. So I wonder why it is that in an investment arbitration, there should be an absolute right of participation when in a case involving, let's say changes to the Texas abortion law that affect every, certainly every woman in the United States and arguably every man in the United States, I don't have any right to participate in that. Why is investment arbitration different or more special? So I'd ask that. I do tend to agree that if double hatting is a serious concern, is something that needs to be policed, then I think you almost have to have a court, because if you're going to say a person can only sit as an arbitrator, essentially can only sit as an arbitrator, no counsel, no other work, and possibly can only sit as an arbitrator in one case at a time, nobody can afford to be an arbitrator because they need a job and they need to pay their mortgage. So then if you're going to limit it, depending on how much you're limiting that, then probably what you really need is a court, so that you really have a defined role and defined standards. And that might be a very good reason, among others, to go ahead and have a court. And on the environmental front, I'll just, like Sergio, and I thought Camille's response was very interesting, because I do think tribunals have shown a fair amount of, let's say, flexibility and receptiveness to, contributory negligence arguments. You mentioned the cases, you mentioned the main cases in which investor, either state liability was reduced or investor, or I should say state culpability was reduced by contributory negligence. And compensation was reduced. And, so maybe that's imperfect, but it's also the case. And I was kind of trying, while Sergio was speaking, I was trying to rapidly review chapter 24. But one of the things that that trade agreements with respect to environment, don't do is they don't really regulate, like they don't require particular regulations. And if you look at chapter 24, it doesn't require any state to do very much. And there's all kinds of aspirational language. And this is, of course, one of the concerns about the environmental chapters, but there's all kinds of aspirational language. There's these no lowering of standards language, there's cooperation about matters of cross-border pollution, cross-border problems. but it's difficult to see how much the environmental chapter is likely to play too much of a role. And I just wanted to make a comment because of something that Sergio said that, is the kind of the, let's call it the peculiarity of the really large, I mean, he mentioned the cases involving oil and gas, which there are many, but you also have a large number of course, the cases, the Spanish solar cases, with a handful of Italian solar cases as well, and a few other countries, where arguably, and this is, you have investment arbitration being used to try to require states to live up to their commitments to engage in sustainable energy, yet those cases are criticized by the same people who are criticizing the use of investment arbitration in the carbon sphere. So I find that interesting, as it seems to me that you could look at the cases as, when I say pro-clean energy cases, as opposed to somehow anti-state, state regulation questions. So I'll stop there.
Thanks a lot, Andrea, for the interesting responses, and also tying it to Sergio's question. So Frank, it looks like it's all now led back to you, right? You have the floor now. Sure, and I'll just pick up the environmental piece first before we touch the broader questions that have been raised. I share the same skepticism about the quality of that language. I think my background was in trade law before I moved in as well to investment law. And there you see in Article 20 of the GATT and the way that it's been worked through by the appellate body, a robust way to create actual space for conflicting social welfare legislation. So I think when you compare it to that, it's not a perfect system by any means, but you compare these much weaker provisions to that, and you realize that countries know how to draft provisions when they want to, and interpretive bodies know how to craft a body of jurisprudence when they see it in the interest of the institution to do that. And so I think there isn't the political will to do that. I don't mean it plays no value, but I think it's quite limited. On this larger question, I don't know that case, Sergio, but I'm interested. I want to take a look at it. But the phenomena you're pointing to is, of course, a very real one. I think some of the suggestions have been made that to preserve or to foreground the opportunity for state-to-state dispute settlement with respect to a serious miscarriage of justice, which I think is one piece of the possible world that might come out of all this. And I agree that it does point again to this, what the EU is proposing in terms of an actual court. Andrea mentioned that about double hatting. Lots of good procedural reasons to think about a court. The concern that some have raised about the court is if you don't resolve some of the asymmetries in the substantive provisions of investment treaties, you risk a paradoxical outcome, is where you have a stronger judicial system that's applying what for many are deeply asymmetrical rules and concerning, asymmetrical to a high degree of concern. So that's where there is no sort of perfect solution on the table that I see that fully addresses the substantive issues about investment law and the procedural issues. And this finally, this issue of sort of gross miscarriages of justice. I'm teaching contracts for the first time this year with my students. We go through, it's sobering and disappointing to see how many small and not so small failures of justice there have been in the history of the common law of contracts as it's been developed in the United States. So to me, in a way, but again, this is a new area for me to think this through. I would not want to see the fact of miscarriages of justice serve to reinforce the necessity of a system which, if you look at it systemically, is contributing, I think, to great inequities and inequalities and issues of justice with respect to developing countries versus developed countries and their investors. There's these larger structural issues. And so, in the same way that in the third-party funding world, the indigent corporate claimant or the impecunious claimant is always trotted out from access to justice reasons.
to justify this tremendously concerning phenomena of third-party funding. I'm concerned that at a certain point, even the reality of miscarriages of justice gets brought out to prop up a system which, in my view, is contributing to some pretty severe structural problems. Thanks.
Okay, thanks a lot, Frank. So this is it. I think there's been a lot put on the table here. That the aim is never, of course, to solve all of these issues and indeed to provoke this sort of conversations. I'm looking at a time, and we are about 16 minutes away. So this is my proposal to the panelists, if they agree. I hope you agree. I think Frank has touched on maybe where it all sits for many parts of the world, which is that maybe the entire system in itself needs to be reformed. And so whether you think about it in the context of TPP, innovative provisions, or CUSMA, or the EU dimension, or things in Asia or Africa or Latin America, the system is structurally deficient, some might argue. And it looks like there's a confluence of that desire to undo what is wrong with the system, although from various pages of the hymn book. So this is one last shot for all the panelists. If you were to make a guess, right, in the context of CUSMA, in the context of reform of the system, in the context of whether ISDS and IRAs are even the place to address environmental and climate justice concerns, it's a 1-minute reflection for you to close your thought on this very important conversation. And I do not want to leave this to starting, but I can call Camille if there's anyone who wants to go first. I'm happy with that to go first. But again, over to the panelists.
Very quickly, I think the USMCA is one building block in a broader dynamic that's ongoing right now, and I think UNCITRAL gathers some of the discussions as we speak, and then we have new treaties signed all over the world with new and innovative provisions, plus that multilateral court system that might one day be established. For now, it's rather a case-by-case basis, but we'll see. There's a lot going on right now, and so I think it's one step in a process that will last a long time. And we'll see what investors think about that new treaty with the number of cases that are filed, I think, in June 2023. that will give a sense of what the future might lead to. Thank you.
Thank you very much, Camille. So you're not calling on your crystal ball for this one. Okay, Sergio.
Yeah, well, thank you for all of you for the inspiring conversation. And yeah, I mean, Frank, as always, points to the core issue here, right? So are we going to address it, right? Some may argue, and maybe I'm not against that argument, but I think there is a lot to be said about the argument that ISDS actually normalizes an extractivist logic, right? Normalizes these colonial practices and now makes them really core to one of the most successful aspects of international law, right? Which is, the fact that there's cases, the fact that there's something to talk, the fact that we're here together. And I do think that, we have to put a deeper lens on that, right? Like, what is the extent to what ISDS is that, right? The normalization of practices that were built on years of exploitation, unfair relationships, really based on this idea of property rights, based on the of this standard of civilization. And that's, I think, the core discussion that I think we should be having, right? And I thank you for that. And, in my private conversations with Frank, I always end up like incredibly inspired to think more about that and reflect that. And you're right. I think these issues of due process are always used to justify that, right? Yeah, but this or this, these exceptional cases, right, are used in these ways to justify a really rather deficient system in many ways. My thought on this is that I think we should move and push in that direction of perfecting this, or if by perfecting is eliminating the system. But the reality is that there is interests here, and political and economic, and I think we have to also be pragmatic in the way to approach this. And I think and by no means I'm suggesting that you're not being pragmatic. I think like you are in many ways. And I think one of the ways in which I was suggesting that your approach is very pragmatic is, and okay, well, eliminate these two elements, right, that are really core to the system, right? One is the third-party funding, which is rather nocive, right? Because this encourages this behavior of, you're not even a rational actor. Now you're a casino, right? On top of that. And that is just, very problematic, right? I mean, with the cost of in ISDS and increasing costs, I wonder, right, how much, they will be willing to keep taking that cost. Although, I keep, seeing more and more cases that are relying on third-party funding. So I think you're into something there, and I have to give some thought. The second one is the aspect of the question of the arbitrators, right? So to what extent, right, this is becoming a political economy in its own, right? That now the arbitrators and the lawyers actually are the main beneficiaries of a system that has all these deficiencies that you point. So we can tackle this. I would say there's a third one, right, that I mentioned, and Andrea picked on this, right? I mean, I think we also have to think of how to also take away claims by those actors that don't really need ISDS, right? I mean, large oil corporations, and depending on how you count, it's either 30 or 50% of the cases, right? So that is not insignificant, right? So in some ways, the exclusion of sectors, right? So maybe setting the target on these incremental changes, right? That could be actually very significant, right? Much more than what maybe your remarks made it sound, right? Because then you have like a transformation in the political economy of the practice of arbitration, a transformation on the way that claims are financed, and the transformation on the main justification, which is like, oh, let's protect these poor oil companies that have like 500 billion or more of subsidies a year, right? And this is and Lighthouser, right? I actually was interesting in the way that he framed these conversations. Like they don't need more subsidies. They don't need another aspect, right? They don't. So then, you're getting rid of a large portion of the problem, and you can still rely on the promise of international dispute settlement. And perhaps there's still some, and I think maybe Andrea and I are more in the agreement with that there's something to be salvaged on that, right? But anyways, those are my remarks, and I'm very inspired with what I heard today. And thank you, everybody, Camille, Frank, and Andrea, and of course, BC for putting this together. Thank you.
Thanks a lot, Sergio. I won't say more. Andrea, straight to you.
Yeah. No, I'm just, I think sometimes I agree with Sergio on just about everything. I mean, everything, as often is the case. But I think we keep coming, I'm thinking even back to Camille's timeline. I mean, it seems like in a way we move in circles. I guess, we hope we're still confused, but at a higher level. Right. I mean, we come back to this idea of system, the system is broken. And Sergio probably knows what I'm going to say, one of the problems is that there is no system, and there never was meant to be a system. There was meant to be a mechanism for the discrete individual ad hoc resolution of individual disputes. But the way that treaties developed and then the way that we have more and more disputes means that we have something that seems to be like a system, but it's because it's not a system, it doesn't function as a system. So it's very prone to criticism as a system because it's not a good system. And, you know, you could say in defense, I could say, well, it's not supposed to be a system. So it's not really fair to say it's not a good system when you say, well, it wasn't designed to be a system. But I think we're past that. And I'll say, you know, we're, you know, to say that there seems to be pretty widespread agreement that it should be a system. If it's going to exist, it should be a system. How do we achieve systematization? And there is where I think I'll align myself be a little bit with Sergio, I don't know, and with, you know, Jose Alvarez, that I'm a little worried that in fact, I'm quite worried that the reforms at, I think Frank will probably agree with this too, that the reforms at Ancestral Working Group 3 don't go far enough. So this idea that you can reform the procedure and that is somehow going to be sufficient, I think is optimistic, but likely too much so that to the extent you have imbalances in treaties that you don't, you know, then I don't think the new court, let's assume we have a MIC, they're not going to be able to fix that. To the extent you have treaties with divergent provisions, you know, you can hope that eventually you have harmonization of decision making so that at least all treaties with let's say a minimum standard of treatment are interpreted the same way, but all treaties with free floating, fair and equitable are interpreted the same way. But you're going to have problems with state sovereignty if you try to merge those categories, right? Because states are going to say, no, we deliberately have a different treaty. How dare you harmonize our treaty in that way? We didn't want to harmonize, you know, we didn't want that. And so I do think this is maybe a missed opportunity that, you know, if you really are going to have this system, that you would want to look at both substance and procedure. And so I'm a little, I mean, I hope, I don't want it to be unsuccessful. I am not cheering for failure in any way, but I'm a little concerned that this is a missed opportunity and that we might have a MIC, we might have appellate body decisions, and maybe we'll be confused at a yet higher level, but we're still not really going to be where we'd like to go.
Thanks a lot, Andrea. And just because a lot has passed on, Frank, this is just 1 minute. So this is where the moderator in me comes out a little bit. I do want us to end at 11:30, and I think we can do this. So Frank, 1 minute. Okay,
thank you. You know, I want to just emphasize again that I'm thinking my way into conclusions I didn't expect to have. So I completely agree with this question of being pragmatic and incremental. I think that actually most law reform, I would say, happens exactly that way. And I think we should continue to do that. But I think my personal concern was that deep in the process of incremental and pragmatic reform, that something was sort of boiling to death slowly. And stepping back from the system and looking at some of the empirical arguments that seem to say that creating a BIT doesn't necessarily drive foreign investment to a country. Eliminating a BIT doesn't necessarily drive investment away from a country. So I start to think in the end, sort of what are we really doing here? And I think in that sense, I think that's a useful question to keep on the table as we go through the process of making these kinds of reforms incrementally and pragmatically as we need to. And the last thing I'd say is, if we want to sort of take the community that supports ISDS at its word, then let's make it fully functional. You know, let's look at the issue of counterclaims. Let's look at some of the issues of the impact on developing countries. And then we can say, if you have serious concerns about the quality of justice, then let's go all the way towards that and not stop halfway, because then I worry that it's becoming pretextual. All right, thank you.
Thank you so much, Frank, and thank you so much to Andrea and to Camilla and to Sergio, and indeed to all the participants. It's been a great conversation. So we're just 2 minutes, at most 3 minutes to the end. I'd like to call on my colleague, who is the current academic director of the MacEachen Institute, Professor Constance McIntosh, to come on and have a say here on our plans going forward, including the excellent collaboration we've done with them and with the Jean Monnet Institute. I've put the links to both centers in there. Boston College of Law have also collaborated on this, so I want to give that shout out to them. Constance.
Thank you so much, BC. So just briefly, we were super pleased when that BC approached us. We were really happy to have been able to support this event as part of the MacEachen Institute's mandate to try to support understanding of complex policy issues. And you really raised a lot today, and I learned a great deal from all of you. The Institute is going to follow up with a briefing note that'll be posted to BC's Viscount Bennett Chair website, as well as to the MacEachen Institute's website. And we'll be hosting the recording of this session on our Institute website as well as a public resource. And I just want to say thank you all so much. This has been fascinating, and back over to you, BC.
Thank you so much, Constance. And to all of you from me, thank you so much. There'll be a second one in the winter, and so more of that soon. But for now, thank you so much to all the panelists and the participants for an engaging conversation on a Friday morning. And I hope you all stay safe. Thank you.
Thank you very much.